Honorable dignitaries, respected teachers, and dear students, greetings to one and all. I'm Dr. Pammi Ushasri. I feel privileged to welcome you all on behalf of Sir C.R. Reddy College of Pharmaceutical Sciences to the third and final day of our IPR workshop. I'm eager to continue our exploration of crucial IPR concepts today. To enlighten us with his knowledge, today we have Mr. Giridhar Shivalanka Garu, Senior Scientist from Dr. Reddy's Laboratories, Hyderabad. I'm glad to invite Mr. RJSD Pavan Garu to introduce the guest to the platform.
Good morning, one and all. This is RJSD Pawan Kumar, working as Assistant Professor in CRD College of Pharmacy. Today, I would like to introduce the young and dynamic personality, Mr. Giridhar Shivalanka sir. He's completed his B Pharmacy in CRD College of Pharmacy 2011 to 15 and completed Masters in Pharmaceuticals, Manipal College of Pharmaceutical Sciences in Biotechnology Department. He have an experience of 6 years in various pharmaceutical industries, companies like Biocon, Intas, and Reddy's Laboratories. And it's great privilege to have him here to share his knowledge with us. I would like to request him to share his knowledge with us.
Thank you, Pavan sir.
Welcome, sir.
Without further ado, I would like to extend a warm welcome to Mr. Giridhar Shivalanka Garu. And students, please join me in giving a round of applause as we invite him to the platform. Sir, the platform is all yours.
Thank you all for your nice introduction, and I'm really glad to join this session. And I would like to thank the management for this lovely opportunity. Can you please confirm if you could see my screen?
Yes, sir, we can see.
Can you see now?
Yes, sir.
Yeah.
Yes,
Thank
sir.
you all. Yeah. So thank you. So this is a very good topic that has been chosen for this session today, which is related patents. Uh, Sorry for this mess up because I lost my PPT. So I could all the material is there in form of PDF and some in slides. Whenever you could not see my content, kindly stop me and then let me know if you could not see my screen. So first of all, I would like to start the session by explaining the basic background of the biosimilars and the generics. So I have background of biotechnology. So this is important topic on behalf of the patent session, because if you understand the differences between generics and the biologic drugs, it is important to know how the patent act works, how the patent is being taken and used by the pharmaceutical companies. So in this biopharmaceutical, can you see my screen now? Is my screen visible?
Yes, sir. You can continue.
Yeah. So if you see the small molecules, if you see the small molecules, this is the size of a small molecule. If we take examples of the some of the small molecules we use in our daily life, like examples like crocin or the various hypertensive drugs and the diabetic drugs which we take, and this is how a large molecule looks like. And the examples of the large biological molecules are the the drugs or the chemical drugs which we take for the cancer treatments, the antibody treatments, for example. Yeah. So uh, how the biological drugs are being made is that they are made from the living cells which are genetically modified. Small molecule drugs are made from simple straightforward chemical manufacturing. So they will have a complex mechanism action, and small molecules will have a direct mechanism. action. So, for example, if you see the biological drug, herceptin is one of the drug which has molecular weight of 1,85,000 daltons. Whereas if we say take an example of Lipitor drug, which is of Intas, which is just 559 dalton. So this is a traditional drug, and on the left right side we can see an example of how a biological drug looks like. And as I quoted earlier, paracetamol is one of the example. And on the right side, we can see the filgrastim, which is made from a bacteria, and also an example of antibody, which is also a biological drug. These are quite complex molecules. And to build up to this, why I've explained these things is we have something called biosimilars. Biosimilars are nothing but whenever a biopharma company makes an innovative product, for example, any antibody which is engineered to act on some disease or something. So those will have those were done by an innovation are called innovator drugs. Whereas whenever the patent of that gets expired, your biosimilar comes into your picture. Biosimilar is nothing but a similar product which is not identical to the reference product. Whereas generic drug is bioequivalent and identical product to the reference product. So with respect to the patent point of view, when we make a copy of a large molecule or the complex molecule, it is called biosimilar. When a chemical drug which can be synthesized in the same way, where we prove the equivalence studies to it and prove that it is identical to the reference product, it is called generic. So once the patent of the innovator product of both large molecule and the small molecule expires, the biosimilars and generics will come into the picture. This is an example of various products that are there in the market. For example, human insulin, which is produced from a typical recombinant DNA technology product. And this is the biosimilar background of it. And you can see these are the recent and the future patent expiration of the major biologics. For example, filgrastim is a Neupogen product, which is a product which is taken for an adjuvant treatment for the cancer treatment. So this, once the innovator product files a patent to it and the patent expires, companies will be granted permission to make a copy of it. So this is a timeline of the various products which are getting expired. So as we know, the drug development will take time, which is the duration of 3 to 5 years for small molecules and 5 to 6 years for a generic for a biosimilar product. So as it takes time, even before the patent expires, a company will be given permission to start development work on it. Once the development work starts, if the company successfully proves the similarity, of it, they will be given approval for drug manufacturing only once the patent of the innovator expires. This is the basic background of a patent. How a patent has to be filed, when it has to be filed, for which, and based on the drug we are making, whether it is generic or biosimilar, the patent, how we have to file and application will vary. This is, I thought I should share this basics before I go into the other topic. So the next topic I would go about is the copyright, trademarks, and the trade secrets. So these words, the terms like patents, copyright, trademarks, and trade secrets are not in, like, they cannot be used interchangeably. So every word has its own significance and has to be used at particular time itself. So for example, patents, with respect to patents, I will share few more examples at the last of the session, but I would like to explain in detail about one of these definitions. For example, if we take copyright has been come into effect in 1957, and there are several amendments that were done, and it is maintained by our Human Resource Development Government of India. And there is an act that is made of patent, like copyright, and it is taken care by central government, and there will be a register of it. What is copyright? It is a right of a owner, and they can use it for commercial advantage. So basically, we have to use copyright word for these kind of categories. For example, music with respect to the cinematograph films, sound recordings, or anything that is artistic, we have to use the term called copyright. And for example, if we take in Netherlands, even smell can also be protected. For example, with respect to the perfume. And there is clear-cut point here which says that there is no copyright protection for ideas, procedures, methods of operation, or mathematical concepts. So for these kind of things like ideas, procedures, methods, and mathematical concept, we have something called patent. And copyright is only with respect to the artistic work that is being made. This is the common way like how it is being protected. So how do you acknowledge that it has to be copyrighted? So it will be in a record form, or it has some kind of proof to which it can be copyrighted. So there is something called Berne Convention, which protects all the kinds of copyrights. So for example, if any music that is being made, any novel that has been made, any translation that is being made, everything goes via Berne Convention only. So there are different types of copyrights. For one example, it is economic rights, and other one is moral rights. Economic rights is if any artistic, suppose any movie has been made, that movie rights will be sold to certain person under the Copyright Act, which comes under economic rights. Whereas moral rights is even it has been sold to it, it has to be acknowledged that this is the art or novel or inspired from so and so the original work. So that has to be acknowledged. So economic rights, for example, economic rights can be transferred for a sum or money or the royalty. So whereas moral rights cannot be transferred. So the original work has to be acknowledged. So generally up to 60 years calculated from the end of the year of author's death, copyright protection will come into effective. In US and EU, it is 70 years from the author's death. So I have taken some examples to explain you few cases where copyright has been levied upon, and these were arguments were happened in the court. So for example, there is a word called Hamara Bajaj. Okay, this is an example of a movie name called Hamara Bajaj, which is produced by John Abraham, and he had taken this title and made a movie called Hamara Bajaj. But as we know, Bajaj is a famous automobile industry, which is the largest two-wheeler production company. So what they have done is they have filed a copyright and trademark infringement against the producer of the film. So the funny thing is how this got settled is this is an out of the court they have got settled it. And one more example I will take, the movie Dabang. In the movie Dabang, what they have done is they have used a line called Jandu Bam for a song in it. And to settle that issue, this Jandu Bam company has filed a case in the court. So to settle that, the heroine of the movie had done several advertisements for the ad Jandu Bam. That's how they settled this. And with respect to trademark, we might have seen various trademarks for various products. I will show some examples. You can see sugar-free gold and Amul. These are the various trademarks. It can be a symbol, it can be a word, it can be some small abbreviations, multiple things. So which will help you identify which product is what. So trademarks have been used to simplify the identification of goods or services as well as their quality or the value. So every product uses their distinguished trademark, and it should be distinctive and should not be deceptive. So that means it should be different from the existing ones, and it should not give you a wrong meaning of it as well. So these are some of the examples you can see. IBM, ICICI, GE are some letters which can be used as a trademark. And symbols, you can see some of the university symbols, and BMWP is one example. And the words, we can see Cipla, Ranbaxy. Designs, we can see various shirt brands or the clothing brands which use different symbols, and the numericals, slogans, and various devices to use as a trademark. And so a trademark is something which is given for 10 years and it will be renewed for unlimited period by payment of renewal fee. So if a company feels they will be identified by certain trademark, they will make sure that they renew it for the lifetime period. And how we use this trademark in our pharmaceutical industry and how it is being infringed. Infringed is someone is trying to copy that. So it is the why we I'm chosen this topic is one of the intellectual property. So every company or the pharmaceutical product will have its own trademark, and they have to make sure that no other company infringes it. I will take examples of few so that you will understand this. So there is this company Amul. They have identified that there are two local vendors in Gujarat, like Amul Chashmagar and Amul Cut Pie stores. These have used the name of Amul to the store name, even though they have nothing to do with the original company Amul. So they have filed this case and won against the local shops. And one more thing is there is one brand called Amoxil, which is owned by Beecham Group. What they've done is they have introduced this brand Amoxil in India in 1990. But the interesting thing is this brand was registered in 1972 only. Whereas the opponent SRK, what they've done is they've used a similar word Limoxil, which is similar to your Amoxil, and they have applied for registration of trademark in 1987, which is later than the 1972. So that's how the Beecham Group has won against the use of the Limoxil word, and they were the respondent, the SRK Pharma here, the respondent, were prohibited from using this trademark of Limoxil. And one more example is Ranbaxy versus Anand Prasad. So there is Ranbaxy, which have used a word called. So these are nothing but the product. For example, paracetamol is the drug which we use, but we know by its name like Dolo 650 or Crocin or several other brand names. The moment some other copies and uses the same word, we get an impression that it could be the same product and the same quality, which will cheat the public. So to avoid that, we have certain brand names which are nothing but the trademarks of it. So Ranbaxy have used a word called Fortwin, and the respondents, the Anand Prasad team, have used something called Ostwin. So the again here, the court has prohibited to use the word Ostwin here to avoid any kind of deception to the public. Next thing is Pfizer versus Intas. Pfizer also, here the case is Pfizer has a drug called Lipitor, and the generic form of it is called Lipicor, which is made by Intas. So Pfizer was not there in India when this drug was being made. So in this case, the court has given permission to Intas that they can manufacture, market, and sell the same drug, even though name is similar to the Lipitor. As there is no other drug as Lipitor in market that time, the court has given in the favor of Lipicor. And Glucon D versus Glucose D. We might have used or seen several kind of products like Glucon D, and Dabur has introduced something called Glucose D, which has been prohibited later onwards. So this is kind of infringement that happens in the pharma industry. So one has to be careful of these infringements, and trademark is one of the important thing that is required for it. And with coming to the trade secret, So trade secret is nothing but any formula. For example, Coca-Cola uses the trade secret of the formula of the ingredients which they add into it. So how do they protect it? So what is trade secret is any new product plans. For suppose as a pharma company, the employees might be knowing what are the new product plans and regarding the product costing of it, from where the material has been procured and which kind of materials is being used in it, and the research reports of it, the business methods of it. So these are all part of the trade secrets that company obeys. So company should have a different ways to protect it. So also the formula, pattern, the program, device, the method or technique or process in which they make the product. So something called a non-disclosure agreement will be taken. For example, the employee has to sign saying that if you have to work in our company, you have to sign this non-disclosure agreement. So this non-disclosure agreement will be signed by the employees of it, saying that whatever information I know from the company will not be disclosed anywhere else. That's how the company protects from it. This is one of the way. And this, if there are several parties involved, suppose the person who is supplying the raw material, they might know which kind of raw material they're supplying to which kind of company. So they will also follow this kind of agreement to it. And there are different types of the agreements, which is mutual or one way. And here the elements of this agreement contains how long you have this agreement for, and what is the definition, what is confidential information here. Is it the device, is it the components of it, and what are the obligations from the receiving party? If I have to not to disclose, what are the like royalty that has been paid to me, and how long I should not disclose? These are the different elements that define keeping the information not to be revealed from the so one critical thing is in trade secret, once the trade secret has been filed, and it should not be disclosed. Whereas patent, any information with respect to the patent uh, will be commonly available in the public domain. But once anybody copies it, even the trademark is available with the public. But once it is in the public, if anybody try to copy it, they will be penalized by court. This is the topic which I thought I'll cover today, and thank you for this. And before closing this, I would like to explain one. I have to show you one patent example which I have with me. So this is the patent that I have been part of through Dr. Reddy's. A typical patent looks like this, patent copy. So if you are interested in knowing any of your own patents or any of patents of any company, you can go to Google Patents and simply type the title of it or the person of it. You will get to know the patents in their name. So what happens is, as I explained you, the trade secret or the non-disclosure agreement, what happens is any patent that a person works on for the company, the patent will be still in the name of the organization. So for example, this is the patent which is part of my work. You can see the applicant still will be my company, but I am acknowledged as an inventor here. So any patent, if you see, it will have the publication number of it, and the entire information is available in the public domain. And you can see the applicant name, who is the inventor, who are and all involved in an invention. And it also contains the title of it. What is the title and which field it is applicable to? So for example, if I read it, the present invention relates to the stable formulation of antibodies and antigen binding fragments, again, human program death receptors or program death receptor ligand, and method for preparing the same. So this patent covers the formulation of an antibody. So you can say it is directed only to PD-1 blockers or PD-1 ligand. So any antibody that has been formulated in a certain way against PD-1 will be uh, like for which the patent has been granted. So if anybody uses the same formulation recipe and um, by without acknowledging or consulting the respective innovator, they will be seen in the court. So this clearly captures what kind of information that has been patented. What is the background of it? So this is generally the different sections of the patent that it contains. The title, what is the field of innovation, the background of it, and these are the different formulations that were tried during this. So these are the different formulations that were tried, and there is something called section called claims. So what are the different claims that were made during this innovation will be summarized in the end. So that claim section is very important because uh, every patent that is being granted will be checked upon against the prior art. Prior art is something that is already there existing in the public domain or in the field of invention. So by cross verifying the current prior art, these claims will be verified. Whether the claim, for suppose, I would say uh, certain formulation of succinate buffer, trehalose, methionine combination will help my drug to stabilize. So they will check whether this combination of components of formulation were used earlier or not in the prior art. So claims are very important for a document. That's all from my side. If any doubts are there, I would like to happily answer them.
Students, if you are having any questions, you can ask. Okay, sir, I think there are no questions. I want to express my sincere gratitude to you, Girdhar sir. I hope our students found this workshop informative. Now, I would like to hand over the session to Mr. K. Raju Garu to deliver the vote of thanks. Raju sir.
Yes, madam. This is K. Raju, working as an assistant professor in the Department of Pharmaceutical Chemistry, Sir CRD College of Pharmaceutical Sciences, Eluru. Today, I am here to extend my gratitude to all the eminent speakers of the webinar, Intellectual Property and Heritage in Digital World, for their presence and contribution to make it a great success. I appreciate Mr. Varun Pulipat. Sorry. I extend my gratitude to our honorable guest speaker, Mr. Giridhar Sivalanka Garu, to take out time from his busy schedule to grace the event. Thank you for inspiring and encouraging us with your words on the workshop. I appreciate Mr. Varun Pulipati, Senior Regulatory Affairs Associate, Parexer International India Safety Services Limited, Bangalore. Dr. K. Ravishankar, Assistant General Manager, IPR Department, NATCO Pharma Limited, Hyderabad. I would like to express my gratitude to all esteemed speakers of the webinar for their presence and contribution to make the webinar a great success. A special thanks to correspondent sir Sri M. Raja Ram Mohan Rao Garu and Principal Dr. Narendra Babu Garu of Sir CRD College of Pharmaceutical Sciences for their constant support to make the webinar successful. Finally, I would like to thank you, all our organizers, program coordinators, and all the faculty members who worked for the webinar with a great responsibility to achieve an intellectual success. Thank you, one and all.
Thank you, Raju sir. Students, you can leave the auditorium, and Girdhar sir, please do leave in the platform for a few minutes.